Hi there, you're watching PROfintech. My name is Eva. Today we'll talk about securities, trust funds, trust fund users, and the purposes trust funds can actually serve. The trust is a legal institution of the Anglo-Saxon legal system. People, especially those from Europe, may find it difficult to understand how it works. This is probably why it is underused in Europe. When you come to think of it, trust creation is quite a profitable business, as it allows saving money and reducing costs by optimizing the tax burden. A trust is often mistakenly regarded as a specific type of company or a special type of legal entity. A trust, in fact, is not a company as such, but a special form of contractual relationship with respect to property, where the first party, the settlor, transfers the property upon the second party, the trustee, for the benefit of the third party, the beneficiary. The entire system is called a trust fund and, legally speaking, is a type of trust in which a specially registered company manages the property of one person in favor of another person. At first glance, this scheme may seem complicated. Let's find out how and why it was actually invented. Some history facts. Trusts originated in Britain during the time of the Crusades, more than 800 years ago. Knights went to fight in the Holy Land and left their families, wives, children, and other dependents at home. In those days, women didn't have the right to own real property, let alone the right to manage a land plot or rent out the land. At the same time, it could be the main source of family income. Before going on a crusade, the knights transferred title to property to their relatives or trusted persons who had to manage the property in the interests of the family and children of the true owner. Needless to say that there were many of those who wanted to profit from such deals. As soon as the knight left home, the designated owner could dispose of the property as he pleased, and under the laws of that time, he couldn't even be punished. To avoid such violations, a new set of rules was gradually developed in which title could be split. This is how the institution of trust emerged in Great Britain. To this day, true trusts can only be established in the Anglo-Saxon legal system countries, while most European countries have a civil law system. One of its essential features is that it doesn't provide for the splitting of title. The system in which a trust is established by one person, owned by another, and the income is received by third parties, is contrary to the rules and regulations in these countries. A modern trust is the process where the settlor of trust transfers the property to the trustee, who becomes the legal owner of the assets under a special trust agreement. The trustee owns and manages the property in trust solely for the benefit of the beneficiary appointed by the settlor. For its services, the trustee receives remuneration. As a rule, it is the percentage specified in the agreement. Use of the assets in the trustee's own interests is a serious criminal offense. Three main parties are usually involved in the creation and operation of a trust, but a trust agreement can provide for more participants. For instance, a trust protector, the person appointed by the settlor to supervise the trustee's activities, can be added. The structure of trust agreements provides for the clear rules and conditions of partnership between the parties, but there are also subtleties due to which trust agreements stand out from a number of traditional legal transactions. Let me give you a couple of examples. An interesting status is assigned to the property for which a trust agreement has been signed. The trust property legally belongs to the trustee, but is accounted for separately from the trustee's other assets. Execution against the trustee cannot be levied upon the trust property, just like execution cannot be levied on the settlor's obligations, as the settlor ceases to be the owner from the moment the property is transferred to the trust. The beneficiary, in turn, can receive property benefits from the trust property without being its actual owner. Quite a good immunity, isn't it? Property participating in trusts is practically inviolable. Another aspect concerns liability for the received or lost profits. The settlor chooses the trustee independently. It can be a notary, lawyer, or other qualified professional. The trustee undertakes to manage the settlor's capital. Even though the trustee doesn't act as the property owner, he is fully responsible for any damage or loss, all kinds of omission related to the investor's property during the management period. Therefore, to make a profit, the classical methods without super risks and super profits are usually chosen. If the settlor wishes to make investments that go beyond the distribution of risks, he has every right to do so. The settlor may order to spend all the money to buy cryptocurrency, and in this situation, the trustee will be relieved of any responsibility. These freedoms are regulated to the smallest details by the trust agreement. These freedoms are regulated to the smallest detail by the trust agreement. Here's another nuance. A trust should have a blocked account subordinate to the trustee. Money can be deposited to this account in any available way, but it can only be used to implement the tasks of the trust, that is, to profit from property transactions. The age of knights and crusades is long gone. Why would anyone want to use trusts and trust agreements today? Let's have a look at the trust objectives, which, to tell the truth, can be quite attractive. First of all, trusts are a means of securing assets. Assets held in a trust cannot be subject of creditor claims and other third-party claims, for instance, raiders. Trust assets cannot be seized. Besides, it is also protection from family members. Upon dissolution of a marriage, the property is not subject to division since it belongs to the trust. And one more thing. Trust funds are both non-accessible to creditors and non-subject to taxation, and tax optimization is one of the basic principles of asset safety. Secondly, trusts are an alternative to the standard will. If the settlor transfers the property to management during his or her lifetime, this is called a living trust. If property is transferred after the death of the settlor, it is a testamentary trust. In case of the testamentary trust, the settlor may appoint multiple beneficiaries and multiple trustees. In the future, the property will be distributed between the beneficiaries, but only after the death of the settlor. By the way, did you know that after the divorce of Brad Pitt and Angelina Jolie, the media disseminated information that all the money jointly earned by the couple during the marriage, and we talk about more than 100 million US dollars here, will be transferred to a trust fund established in favor of their 6 children. Thirdly, a trust is an effective way of owning property for both personal and business purposes. In this situation, it is a tool that ensures the safety of property with low taxation and decent profit. Such companies are mainly focused on the owners of various types of real property, securities owners, and offshore organizations. It is important that trusts provide comprehensive anonymity for beneficiaries. When a trust is established, the name of and settlor-related information is not entered in the registries and appears only in the deed of trust. The only known owner is the trustee. To successfully create a trust, 3 basic conditions must be met. The first condition is the legal status and capacity of the settlor. The settlor of a trust can be either a private individual or a legal entity. A private individual must be of legal age. On behalf of a legal entity, a trust can be created by the company's director or manager. The settlor must be of sound mind and memory, and this must be confirmed by an independent notary before whom the settlor and the trustee will sign the agreement. The second condition is solvency. The person who transfers assets to the trust should not show signs of insolvency. Otherwise, creditors can prove that the trust was established to avoid paying debts. The third condition is timeliness. A trust cannot be created retrospectively. And since it solves many problems and the very agreement of the terms and conditions can take a long time, it is advisable to plan your trust well in advance, before your assets need urgent protection. As to duration, a trust cannot continue indefinitely. The terms are determined by the laws of the country where the agreement is signed. In the UK, the historical approach has been preserved. A trust can last for a life in being plus 21 years. There are slight variations in other common law countries, while in most offshore jurisdictions, trusts are created for no more than 100 years. By the way, did you know that besides the fact that a trust cannot continue indefinitely, it cannot be purposeless? This is why the agreement prescribes what should happen to the property if there are no beneficiaries left. The trustee must know what to do with the property in this case and where to direct the income. For instance, it may happen that 3 lines of beneficiaries were registered, but 100 years have passed and the line has dried up. The trustee must dispose of the rest of the trust property as specified in the agreement, for instance, to donate it to charity. Private trust companies are a separate type of company. Upon registration, they receive the PTC abbreviation in their name. Such a company is registered when one family has one asset and wants to create one or more trusts in favor of their family members only. Private trust companies provide the possibility to do that without the financial institution formalities. For this, the company needs its own trustee, which will act in the interests of one family, will not offer its trust services to third parties, and will not receive remuneration for its services. There is no requirement to obtain a special permit or license for such a pocket trustee managing the property in the interests of one family. By the way, a private trust company allows a family to choose who will provide trust services and change trustees over time. In many cases, a private trust company allows the family to be involved in key investment and management decisions. Securities are often mentioned when talking about trusts. The point is that trust fund assets need to be managed, invested, and earned. The easiest way to do this is if the fund assets are in the form of securities. First of all, let's find out what securities are. Securities can be definitive or book entry. Securities confirm the availability of capital and can be transferred in its place, or can be traded on the market as a commodity and make a profit. Simply put, securities are not the capital, but all the rights to it documented therein. It is important that securities need to be actively used, that is, be in circulation. That is why it is necessary to work with them on stock exchanges and funds. Depending on the purpose, there are stock securities and commercial papers. Stock securities, or stocks and bonds, are investment instruments. They are traded in the stock market and are usually perpetual. Commercial papers, or bills of exchange and letters of credit, are credit instruments, short-term debt obligations with a fixed income. These papers are mostly short-term, valid for no more than 1 year. They are rarely used to invest capital. Also, there are marketable securities which can be resold and non-marketable securities which can be sold only once. All securities were initially issued in paper form and were as valuable as money. Their value can be determined either by the denomination written on it or by the market. Securities have a number of properties moving them closer to money. They can be used in calculations, be pledged, stored for many years, inherited, and donated. So trust funds are an interesting form of property management, and a huge fortune is far from a mandatory aspect here. For instance, a parent who wants to save money for a child's education can create a trust fund, and the child can get the money upon reaching a certain age or after graduating from school. Trust creation is quite a profitable business that allows reducing costs and saving the assets of companies and private individuals as well as family capital. As they say, there are no bad trusts, there are poorly written ones. To protect the settler's assets and the beneficiary's income in the future, it is recommended to have one or several consultations with a trust specialist in the trust creation phase. Please remember that there can be no common templates or form for trust documents. There are enough trust companies on the market that offer so-called free-of-charge trusts. However, their only goal is to get assets under management and earn money themselves rather than care about the benefit of the beneficiary. Their trust agreements are usually written skillfully and elaborately, but not in the client's favor. Most often, transferring such trust to other companies is almost impossible or requires quite large compensation. That's it for now. See you in the next pros.